I declare the 20th session of the Assembly of States Parties to the Rome Statute of the International Criminal Court open. It's a privilege and an honor for me to welcome you all here to this session, and we are celebrating yet again this session under the COVID-19 related restrictions. Like all of you, I'm very saddened by the worsening situation, and I'm frustrated that we are having to restrict participation once again, albeit on the part of states or civil society, and some of them have had to cancel their participation in this assembly. Be that as it may, I trust that we will be able to have a vibrant, productive session. I'm looking forward to hearing and interacting with you personally over the course of this week. My thanks go to the host state for their flexibility in enabling this assembly to implement its own measures when it comes to the health and the pandemic, and for facilitating access to representatives in this assembly. Please rest assured, everybody, that the World Forum Convention Center has implemented measures so as to minimize the risk of exposure to the virus, so that all participants will be safe, and I invite you all to respect those measures. Thank you all very, very much for your patience and understanding. As you know, the agenda for this particular session is an ambitious one. We will be discussing in particular some of the key issues of cooperation and the review mechanism of the court and the Rome Statute system. We will be approving the budget for 2022, and we'll be undertaking elections for important bodies of the court, such as the Board of Directors of the Trust Fund for Victims and the Advisory Committee on Nominations of Judges. And finally, but last but not least, we will be electing 2 deputy prosecutors. Now, before moving on, I should like you all kindly to be standing so that we can observe a minute of silence for prayer or meditation, in particular for victims.
Muchas gracias.
Thank you very much. And a word on seating arrangements. On the basis of a draw undertaken by the Bureau, the delegation of Australia will be taking its seat to the right of the presidency, and all of the other states are to follow alphabetical order in English. Now, as you know, so as to minimize the health risk and to ensure everybody's well-being, the Bureau has decided that the number of representatives of states parties in the World Forum Convention Center at any given time will be limited to 2 individuals. Dear delegates, in accordance with paragraph 1 of Article 112 of the Rome Statute, states that are not states party to the statute, but which have signed the statute of the Conference of Rome, may participate as observers in this assembly. Observer states can take part in the discussions of the assembly, but are not part of the decision-making process. Those states that are not states party to the Rome Statute and have not signed the final act or the statute do not have observer status. And under Article 94 of the Rules of Procedure, at the outset of each session, the President may invite those states to be present during the work of the Assembly. This is subject to the approval of the Assembly. So I should like to propose to the Assembly that we invite the following states who do not have observer status to remain present during the work of this Assembly: Bhutan, People's Democratic Republic of Korea, Equatorial Guinea, Eswatini, Lao People's Democratic Republic, Lebanon, Mauritania, Micronesia, Myanmar, Niue, Palau, Papua New Guinea, Rwanda, Somalia, South Sudan, Tonga, Turkmenistan, and Tuvalu. May I take it that the Assembly would like to invite these states to remain present during their deliberations? I see Mexico. Mexico, you have the floor. Thank you very much, Madam Chair, and congratulations on your stewardship of our meeting. We wish you every success in this session. Just wanted to check if they are, since they're invited to be present, do they need to present credentials? Thank you very much for your question, Mexico.
Buenos días. En efecto, los estados
Yes, indeed. These kinds of observers don't actually have to present credentials, but they do need to give us the makeup and composition of their delegation, but they don't need to pass through the credentials procedure. Thank you. I hope that this has satisfied your question. May I then take it that the Assembly would like indeed to invite these states to be present during their deliberations? I see no objection, and so it is decided. Seats have been reserved for observer states and invited states, but given the limitations imposed by the pandemic, only 2 representatives of each of these states may be present in the World Forum Center at any given time. Only 1 representative will be able to sit behind a microphone, while the second individual should be seated either at the back of the room or in the balcony section. I should like to extend a particular welcome to the representative of our observer states, because and that means those who are present in the room here and those who are following us online. As always, the Assembly highly appreciates your presence and participation in our session. We understand that many of you would have liked to have come and even planned your trip to The Hague, but because of the worsening epidemiological situation, you were not able to make it here to be with us. Seats have also been reserved for non-governmental organizations who are invited under Article 93 of the Rules of Procedure. Here again, it's the health restrictions that have forced us to limit the number down to 16 NGO groups present here in the World Forum at any given time. And we do regret all of these restrictions, but we thank you all very much for your understanding. Now it's time to move to the approval of the agenda. The provisional program can be seen in document ICC ASP20/1, and there's an annotated program in document ICC ASP20/1/add1. May I take it that the Assembly is ready to approve the schedule of work as it figures as it occurs in document 20/1? I see no objections. So the agenda is duly approved. And now I have my gavel. Thank you. And now I'm going to be switching to English.
Report on the activities of the Bureau. Distinguished colleagues, in accordance with the agenda we have just adopted, we will hear a number of statements this morning. In order to minimize any health risks, I would ask all speakers already on the podium to please speak from their seat. I thank you for your understanding. As the President of the Assembly, I have the honor to report on the activities carried out by the Bureau of the Assembly of State Parties this year. The full oral report of the Bureau will be included in the official records of this session. In the interest of time, I will not read this in detail. However, I do wish to make a few remarks at this point. Indeed, I have the honor to report to the Assembly of State Parties on the activities carried out by this Bureau since 13 February 2021. In light of the circumstances caused by the COVID pandemic, the 9 meetings held by the Bureau this year have been held virtually. The working groups of the Bureau, facilitations and focal points, as well as the review mechanism, also met virtually. The Bureau assigned mandates to its working groups and appointed, on the basis of their recommendations, the facilitators and focal points for 2021. The Bureau deeply appreciates their work as they have successfully carried out the mandates of the Assembly. I also wish to express my sincere appreciation for the work carried out by the 2 Vice Presidents of the Assembly, Ambassador Bob Ray from Canada and Ambassador Katerina Sekwensova from the Czech Republic, in support of the work of the Bureau and as the coordinators of the New York Working Group and the Hague Working Group. In accordance with the mandate of the Assembly, the Independent Oversight Mechanism, IOM, submitted the annual report of the head of the Independent Oversight Mechanism to the Assembly and also provided invaluable assistance to the design and implementation of the due diligence process approved by the Bureau for the selection of candidates for the positions of 2 deputy prosecutors. I wish to express my appreciation to the head of the IOM, Mr. Saklen Hedarali, for the important work undertaken by him and his office. I also wish to express my gratitude to the Secretariat of this Assembly. Throughout the year, the Secretariat has continued to carry out its mandate in assisting the Assembly and its various groups, facilitations, and the review mechanism both in The Hague and New York. The virtual format of the meetings continued to pose additional challenges, including scheduling meetings across multiple time zones, additional testing of numerous platforms required prior to meetings, and finding solutions for the provision of interpretation where necessary. At its first meeting in February, the Bureau agreed to engage in a lessons learned exercise with respect to the last prosecutor election process. To this effect, the Bureau requested and received reports from the former presidency of the Assembly, the Committee on the Elections of the Prosecutor, and the panel of experts. On 2nd November, the Bureau adopted a proposal on the mandate, principles, products, and deadlines of the lessons learned process, as well as the appointment of 2 state representatives as the facilitators. They are now reviewing the background material and will start their preparations and consultations in the first trimester of 2022. I propose to invite them to report to the Bureau on their activities as soon as feasible in that first trimester. Also, during this year, the Bureau adopted a joint proposal with the prosecutor on a due diligence process to assess the high moral character of the candidates for the position of deputy prosecutors. This process was implemented as foreseen, and on 18 November, the IOM submitted to the Presidency a report concluding that there was no evidence of misconduct that warranted informing the Assembly as to the risk that any candidate may not be of high moral character as required by the statute. The Presidency accepted such conclusions and reported to the Bureau that therefore considered that no further action was required. On 24 November, the Bureau took note of this oral report. The Bureau will subsequently consider whether this experience could be applicable to other future elections. Regarding the election of deputy prosecutors, divergent views were expressed by Bureau members regarding the interpretation of Article 42(4) of the Rome Statute, in particular, whether the state should select the candidates from one list of 6 or 2 separate lists of 3 candidates. The Bureau agreed to recommend to the Assembly that A, the election of the 2 deputy prosecutors take place on the basis of List A and List B as submitted by the prosecutor to the Assembly. B, the election of the 2 deputy prosecutors be done successively so as to ensure equitable geographical representation of regions and legal systems. The order of the election between the 2 lists would be determined by drawing lots at the Assembly on the day of the election. The Bureau also agreed that its recommendation is understood to apply solely for the purpose of this election and should neither be considered as a precedent for future elections nor construed as acceptance by state parties of the interpretation of Article 42, paragraph 4 of the Rome Statute that resulted in the presentation of 2 distinct lists. The Bureau considers that this matter requires further consideration and discussions at the earliest opportunity in 2022. Distinguished representatives, since the start of my presidency in February this year, I have used every opportunity to highlight the importance of the Court as a central piece of a global system of justice. I have stressed that for the Court to discharge its crucial mandate in light of contemporary challenges, it is necessary to take actions in 3 areas, namely to review the entire Rome Statute system with a view to improving and strengthening its functioning, increase cooperation, and support and enhance universality of the Rome Statute system. To this effect, I have engaged with the diplomatic community in The Hague and New York, and have also actively reached out to civil society organizations. In September 2021, I visited New York, where I delivered remarks at the annual meeting of the Informal Ministerial Network for the International Criminal Court, and met with representatives of state parties, high officials of the United Nations, and civil society organizations to foster understanding and cooperation for the Court's activities and seek to enhance universality and political support. I have also specifically discussed the importance of countering the instances of non-cooperation. In this regard, I have indicated in the context of discussions of the review mechanism that it would be important to address in 2022 the recommendations of the independent experts on external political measures against the Court. During this year, I have engaged on several occasions with the Board of Directors of the Trust Fund for Victims, which I consider a crucial component of the Rome Statute system. I have emphasized on multiple occasions the importance of supporting the Trust Fund for Victims and wish to express my appreciation to states that provide financial contribution contributions to their activities. In concluding, I take the opportunity to thank all my colleagues of the Bureau for their hard work and invaluable cooperation and support to me during these intensive 10 months. I thank you for your attention. May I take that is the wish of the Assembly to take note of the oral report of the Bureau? I see no objection. It is so decided. The Assembly has thus concluded its consideration of Agenda Item 9. Now we will turn to Item 6, Report on the Activities of the Court. This report is contained in document ICC ASP20/9. We are honored to have the President of the Court, the Prosecutor, and the Registrar present today. On behalf of the Assembly, it gives me great pleasure to extend to them a warm welcome and to assure them of the continuing support of the Assembly in the discharge of their respective responsibilities. The Assembly is aware of the enormous responsibilities inherent to your offices. I will invite the President of the Court and the Prosecutor to address this plenary today. The Registrar, Mr. Pistol Lewis, will deliver remarks to the Assembly when we take up Agenda Item 16 on considerations and adoption of the budget for the 20th financial year. I shall first give the floor to the President of the Court, Judge Piotr Hofmański. Judge Hofmański, you have the floor, please.
Madam President of the Assembly, Mr. Prosecutor, Mr. Registrar, Madam Chair of the Board of Directors, Excellencies, distinguished representatives of states and civil societies, ladies and gentlemen, it's a great pleasure for me to address the Assembly of State Parties for the first time in my capacity as President of the Court. I would like to begin my remarks by thanking all states, organizations, colleagues, and others who have given their support to me in my new roles and since I was elected President on the 11th of March this year. I really appreciate it. Madam President, if I had to summarize in one sentence what I want to say today, it would be this. The Court is on the good path. The Court is doing more than ever in those concrete delivery of justice through investigations, trials, and reparations. The Court and the Assembly are working closely together in the review process, which is already yielding positive results. And the Court has survived the most challenging period of institutional threats against it since its creation. None of this means that our daily work is simple or easy. Far from it, but it is reassuring to see the Court succeed in discharging its mandate, while it is also improving as an institution. I will not enter into the details of the Court's judicial work here, since the allocated time slot is far too short for that. Suffice is to say that the Court is very busy, working at full capacity and speed. In the past 12 months, a large number of significant decisions were issued, including 2 major appeals judgments, 1 trial verdict, 1 sentencing decision, 1 reparation order, 2 decisions on the confirmation of charges, 1 decision authorizing an investigation, and so on and so forth. And despite of the significant challenges posed by the global pandemic, The proceedings in our courtroom have non-stop at any point. 2 trials have been occupying our courtrooms this year, 2 more will follow next year, and there could be a 5th one as well. We may well be handing to the court's busiest year ever in terms of trial proceedings. Meanwhile, the number of situations before the court has reached the record level of 16, more than double from 10 years ago. The workload of the Trust Fund for Victims has equally increased in a dramatic manner in recent years, as it plays a key role in delivering the reparative aspects of the ICC's justice system. All of this shows the ICC is doing the job it was created to do, and despite challenges. It shows that the court is relevant and legitimate. And it shows that the court enjoys broad support and cooperation, as without that, all this work could not be carried out. One more note. I would like to express the court's sincere gratitude to all those states, parties, other states, international and regional organizations and NGOs that have extended their support and assistance to us in the past year. Thank you. Madam President, apart from the unprecedented workload of the court, a theme that has strongly characterized the past year is the review of the court and the Rome Statute system. The review resonates strongly with my top priority as a president of the ICC, which is to enhance the court's delivery of justice in every way possible. Independent, impartial justice, fair to all parties and participants. Since day one of my presidency, the court has been working closely with the assembly of the review process. We must make it a shared success of the whole Rome Statute system. We have already seen the usefulness of the IR report, as it has pushed us all forward to tackle many areas where improvements can be made. We may not agree with each and every recommendation, but that was never the point. The main thing is that the process as a whole creates positive change. It is not easy for judges to work on the complex IO recommendations on the top of the heavy judicial workload. But we are doing it, and we have made a lot of progress. Just 2 weeks ago, at the annual Judges Retreat, it's a tradition started by President Fernandez. The court's judges jointly decided on several important measures in response to the IAR report, which a view to enhancing the efficiency and consistency of proceedings before the court. These agreements, which concerns the pre-trial to trial transition, the conduct of trial proceedings and the approach for victims' applications, will be reflected in the Chamber's practice manual as well as proposed amendments to the regulations of the court. Discussion at the retreat will also address questions related to the collegiality and workplace culture. The latter issue is in particular is one of the highest priorities for the court's management. We must guarantee a safe and fulfilling working environment for everyone in the court. The court is doing a lot on this front. We have appointed a full-time focal point for gender equality. And she has already made a tangible impact. We are creating an ombudsman person next year if the Assembly approves the budget for it. We are right now conducting a staff engagement survey to get updated and more detailed perspectives on the staff members on their working condition. We are also far advanced in updating key administrative issuances aimed at addressing bullying, harassment, and related matters. And we are soon launching public consultation of the Court's first comprehensive institution-wide strategy on the gender equality and workplace culture. On top of all this, I want to show example by digging deeper into this topic in my own immediately area of responsibility, the judiciary. To that end, I have requested the independent oversight mechanism to conduct an evaluation of the staff working condition, the presidency and chambers. I hope the SP will approve this as part of the IOM's work plan for the next year. I want to get an in-depth, independent evaluation of the state of affairs so that we have a precise picture of where problems lie. Madam President, at the beginning of my remarks, I referred to the deeply regrettable period of attacks and sanctions against the ICC, which is thankfully now behind us. The period taught us that the Court, its mandate and its independent operation cannot be taken for granted. In that context, I urge the Assembly to give utmost attention and deep consideration to Recommendation 169 of the Independent Expert Report. It is essential that we are all better prepared for possible future threats against the ICC. If the Court is allowed to do its work independently, which is the cornerstone of this very idea as a judicial institution, then we are bound on the end to end up on a collision course with powerful interests every now and then. The ICC community of states and stakeholders must make it abundantly clear to the world that the Court and its independence will be safeguarded with utmost guidance. We cannot afford to compromise on the rule of law, and that is ultimately what the ICC represents. I am of course aware that the rule of law in the international arena is not exactly the same thing as it is in the domestic setting, but the two are very closely connected, and we must promote both. I believe this is also one of the questions that should form part of the discussion of the long-term strategic vision of the ICC provided in the recommendation 363 of the IO report. The Court stands ready to work with the Assembly on this important matter. Madam President, thank you for this opportunity to address the community of states and other stakeholders gathered under the umbrella of the Rome Statute. As President of the ICC, I pledge my full commitment to leading the Court forward as well as I possibly can in the next 2 years, and working closely with you and everyone else here for the cause of justice, as we have indeed done so far. Thank you very much for your attention.
I thank President Hofmansky for this very concise but still comprehensive statement on the impressive and intensive work at the Court. I thank you very much, President Hofmansky, and I now invite the prosecutor of the Court, Mr. Karim, to address the Assembly.
Madam President of the Assembly, Silvia Fernandez de Gomendi, Mr. President Hofmansky, dear Mr. Registrar, I'm seeing Chair of the Board of the Trust Fund for Victims, Excellencies, distinguished delegates, it's an immense privilege and honor to address you in this very important occasion, my first address as prosecutor of the Court. Since I was appointed commenced my term on the 16th of June, there's been a great deal of activity for which I commend every member of the office for playing their part. I will also touch upon the wonderful support I've had for so many at the end, including the principals that I have the honor of sitting alongside at this table. Wonderful engagement with many of you, representatives of state parties, and also constructive engagement with non-state parties and civil society. We have started a process that has a way to go, but it is a start that will require the refocusing of the energy and skills of the office to help ensure that we make a greater impact. In this regard, I'm tremendously grateful for the work of the independent expert review. It put up a mirror to the court at a very important time. And many of those recommendations definitely deserve to be embraced. And I will do so in full conformity with my Article 42 responsibilities for the management and organization of the office. The simple truth, as the IAR report discloses, is that the time for change is ripe. It is now. As we approach the 20th year of the coming into force of the Rome Statute, we need to build upon what works, the achievements that undoubtedly have been made, but with a constructive but critical self-reflection and degree of introspection that we need to do better. Because all of us in this room, and those distinguished members watching online, civil society in the field, state parties or non-state parties, have to face an ugly reality that for far too many individuals, there is a lack of protection. They suffer. And there are these islands of impunity that cannot be tolerated in this 21st century. I will make every effort to bring about change. The staff that I have the honor of leading work tremendously hard. We deal with expectations that perhaps also need to be moderated based upon an understanding of what international criminal justice can do and what it cannot do, what the court has, what resources are given to me as prosecutor to do my job, and to focus what we have in an intelligent way so that we can make a difference. Before I was elected, and I stated it to the distinguished delegates and state parties in roundtables, I was convinced that this office should be the most exciting, the most vibrant, and the really most wonderful place in the world to work. Yet, as the IAR report discloses, it is not. And this is not apocryphal. As I walk the corridors of my office, as I have had my weekly open door policy with staff, I can see that for far too many of them, their enjoyment depends upon who they work for, which team they are in. There are changes that we have to bring about, and to this end, I'm very grateful for the advice that I was so generously given both by the registrar, by the head of the IOM, and I've had discussions with all of the principals, and I've appointed a workplace panel of experts outside of the line of reporting that staff can go to in safety. It's a safe space with full confidence, so that any issues of harassment or bullying or sexism or racism can be properly put forward. And so I am given some granularity further to the IAR report. One commitment I make without hesitation is that I will not speak the language of zero tolerance and fail to implement it. I think that is the very least that is required of me. On Friday of this week, we have a workplace panel side event chaired by Mr. Ibrahim Pam, in which all the panel members will be speaking, along with my newly appointed special advisor on workplace culture, Ms. Perna Sen. And I do hope that some of the distinguished members in this room and those online would have time to watch it, and if they are otherwise engaged, to watch the recording. I've also appointed special advisors on new areas, about 20 special advisors, but on new areas such as gender persecution, on slavery crimes, on Islamic law, on knowledge transfer, and this week I will announce the appointment of a new special advisor from Japan on mutual legal assistance. One other thing is clear, that gender parity, gender equality, and proper fair geographical distribution is not a tick box exercise. It is essentially linked, particularly in the work that we all do, to the delivery of the mandate of the court. It is important to understand the regions in which we operate, and hearing the perspectives from a variety of individuals is also critically important to understanding intersectionality when it comes to the crimes that are targeting civilians, and when we hear the stories of victims and survivors. Before I was elected, and in the first 6 months of this current mandate, I have repeatedly emphasized, and forgive me for underscoring it again, that complementarity is a key aspect, a key bedrock foundation of the Rome Statute system. And my own view, subject to witness security, logistics, finance, and of course the decisions of the independent judges of the court, The Hague should not only be, the ICC should not only be a court of last resort, but The Hague should be a city of last resort, and we should look at concrete ways in which we can build partnerships to bring the court closer to the affected communities. I think, indeed I'm convinced, that the impact would be greater if we do that. My missions to Colombia and Venezuela may provide an insight into new models that I believe are fully consistent with the Rome Statute and which are capable of bringing about real dividends. I recently went to Bogota in Colombia, and I announced the closing of a preliminary examination that had been open for 17 years. I did so because a proper assessment of what Colombia had put in place, the $120 million a year it was providing to the Special Jurisdiction for Peace and the Justice and Peace Tribunal, could not disclose a lack of genuineness. There was no evidence to find unwillingness and inability. And realizing the function of preliminary examinations as a filtering function, I was compelled to close. But with the wonderful support of the Colombian ambassador in this room, with the Colombian government, we started what I think is a new paradigm of engagement, constructive engagement outside of the preliminary examination, by way of an agreement that the President and myself signed when I was in Bogota. This is something that I would urge everybody to support. It would be a way of securing the independence of the Special Jurisdiction for Peace, to ensure that there is no political interference with it, and that it is properly funded, and it is a way to work closer with states instead of unnecessarily diluting our efforts in a way that would otherwise be quite possible. I was delighted to accept an invitation by the President to visit Colombia again next year, and I hope we will have ever closer relationships and supporting the Special Jurisdiction for Peace and the quest for Colombia is making to deal with impunity, to deal with the crimes and the suffering that have befallen them for far too long. And this is completely consistent with what I've said repeatedly. The forum is not important. What is important is there should be no deserts of impunity. We need to water the ground and create oasis of accountability wherever possible. And I was also delighted to visit Venezuela, and I'm very grateful for the interaction with the ambassador of Venezuela here. I had very good meetings with the president also of Venezuela, with the senior members of the government. And in the presence of the president and senior members of the government, I also announced an opening of an investigation. I do think it's important to underline to everybody what I emphasized when I was in Caracas, that preliminary examinations are a filtering process. And when investigations are opened, there's no preordained targets. There cannot be. There's no preconceived outcome. The job of any independent prosecutor and the job of my office is to follow the evidence and see what actually is the reality. See if Rome Statute crimes are committed, and if they are committed, to see whether evidence discloses who is responsible. This office is not in the regime change business. It simply and must solely try to address impunity and investigate independently. But what was important in Venezuela, in a first, in fact, was that at the same moment I opened a preliminary, an investigation, I signed with the president of the Bolivarian Republic of Venezuela an agreement which shows that together with investigations, in parallel with investigations, we can have cooperation based upon complementarity, and I look forward to constructive and sustained dialogue with Venezuela to address impunity in national proceedings. I look forward to going to Venezuela also next year and to further that interaction. As these two examples show, Venezuela and Colombia, it signifies a new approach perhaps to preliminary examinations. The comprehensive review that I have started, looking at preliminary examinations, looking at policies, investigations, will seek to use the finite resources of the office more effectively and to build cases that will survive challenge in the courtroom. I hope to announce certain decisions on preliminary examinations before the end of the year, and in relation to all outstanding matters, come to those determinations by the end of next year. Of course, new preliminary examinations will be opened, and new investigations indeed, whether by Security Council referrals, state referrals, or Article 15 propria moto investigations. But for all of these matters, the basic function of preliminary examinations must mean that they do not take any longer than they are required. I will announce in relation to new preliminary examinations, new investigations, certain situations where I will not open new cases and I will not conduct new investigations. I think this is in line with both the IAR report, and it's also in line with the officer's policy on case completion. I will continue to solidify ongoing investigations. I gave my report recently on Libya to the Security Council, and I emphasize there that all things being equal, I will prioritize referrals by the Security Council. I demonstrated my adherence to this by, in August, going to Sudan. We agreed an MOU with the government of Sudan, and they also agreed to have our office open an office in Khartoum. Whilst the coup has caused a bit of a hiatus, I look forward to members of my office, subject to security and the issuance of visas, going to Khartoum again. We can look at the Sahel region. We can see the spread of ISIS. This is another area of concern to the office that we're reviewing. And in relation to Afghanistan, I made a decision based upon the evidence that the worst crimes in terms of gravity and scale and extent seem to be committed by the so-called Islamic State Khorasan and also the Taliban. And I said I would prioritize these, and I've asked the judges for authorization to open those investigations. I want members to recall that in 2014, my predecessor Fatou Bensouda, in relation to Darfur, told the Security Council that she would hibernate Darfur because of overstretched resources, and she was shifting those resources to other cases. I have not sought to hibernate, but I have sought in a very transparent way to explain where I will seek to investigate, what I will seek to prioritize, and what I would seek to deprioritize. We have to, every national prosecutor has resource issues. We have to use it wisely. But I'm a great believer in the wisdom of Voltaire, and as Voltaire said, perfect very frequently is the enemy of the good. And this is also something a prosecutor must bear in mind. The President has discussed the progress in courts in terms of the cases. The court is busier than ever. In Yakutom, in Ganasona, the Said case, we've dealt with 52 witnesses in Said. In the Al-Hassan trial, we are progressing, and the Deputy Prosecutor has been overseeing the imminent commencement of an Article 70 case. Regional engagement needs to move more closely, and I look forward to regional cooperation with Asia, with Latin America, and also with the African Union. And I've met President Tshisekedi, President of the African Union, President Macky Sall, the incoming president, and I look forward to meeting President Faki of the AU Commission soon in anticipation of addressing the African Union Heads of State Summit in Addis in February. A lot more can be said, but I had a note. I was told I could have 15 minutes, but it seems I got that wrong. It was 10 minutes. So can I just end by thanking Madam President, you for your support, the President, President Hofmansky, the Registrar, James Stewart, and really all of you for the support and the warm welcome in this initial period. I would like to also thank the outgoing chair of the Trust Fund for Victims, Mama Doumbia. Wish her the very best, and the work you do in your board is something we should never lose sight of, and we should all support, because it is immensely impactful for the individuals. My final word has to be this: I will not shirk my responsibilities. I will take the tough decisions in terms of the quality control of the office and where we focus. But I do ask the respected members of this Assembly of State Parties, our parents, the guardians of the Rome Statute system, to not shirk your responsibilities. I made a budget request. The court put forward a budget request. The CBF has recommended only half of what we say we needed in what was a very well thought out budget proposal from the court. I do ask that the respected members of the Assembly of State Parties work with the budget facilitator and at the very least meet what the CBF have recommended. And I think actually we do need more to harness technology. If we work together, if we fulfill the promise of this Rome Statute, we can do work that will outlast us, that will outlive us, and could make a very meaningful difference to so many who are suffering so much as we sit here in this room in The Hague. Thank you so much.
I thank the Prosecutor Khan for this extremely informative statement, also for his invitation to all of us to do better. I'm sure we all want to join in this invitation. And I now propose that the Assembly take note of the report of the International Criminal Court contained in document ICC ASP20/9. I see no objection. It is so decided. The Assembly has thus concluded its consideration of Agenda Item 10. Now, with your permission, I will switch into French to turn to the rapport du Conseil de Direction.
The report from the Board of Directors of the Trust Fund for Victims. Distinguished colleagues, now we are moving on to item 11 of the agenda, which is a report of the Board of Directors of the TFV and the report of on the projects and activities of the board from the 1st of July of 2020 to the 30th of June of this year are in document ICC ASP20/14. I have the honor to hand over to the chair of the Board of Directors of the TFV, Madame Mama Koité Doumbia.
Merci, Madame la Présidente.
Thank you very much, Madam Chair. Thank you very, very much for your kind words. Madam President, Excellencies, ladies and gentlemen, on behalf of the Board of Directors of the TFV, I send warm greetings to all of those who are meeting here in person and to those who could not make it to our meeting because of the COVID-related measures. Today I have the pleasure of reporting to you for the second time in front of this august assembly as chair of the Board of Directors, our activity report as the chair of the Board of Directors of the TFV, and I'm going to also mention some of the challenges we're facing. And it's also the final time that I will have this honor, because the current Board of Directors is reaching the end of its term of office. And that is why I just wanted to mention yet again all of my recognition to my fellow board members who have supported me in my role and have always given their unwavering support to the work of our body, making sure that we could discharge our mandate in favor of victims. I wanted to express my deepest gratitude to Madame Baron Imenka, representing the European states, Mr. Sheikh Dr. Mohammed, representing Asia, Madame Minou Caloes Milabel, representing Latin America and Caribbean, Mr. Gnusha, representing Eastern European countries. And finally, a welcome to Andres Parmasa, who was appointed to the board in April of this year and taking over from Mr. Gusha, who became appointed as a judge to the ICC. I also wanted to mention that we were looking at the nominations for the Board of Directors, which I know will ensure the continuation of the mandate of this important body. Over these last few years, we've given our best and brought around some significant innovations, provided our expertise and our energy, and really giving the best that we can, since we're working on a pro bono basis for the funds. That's our way of contributing to giving hope to victims, their families, communities, and building heightened trust among the donor communities. The 6 projects that we undertook in this period actually was just part of what we took over, which was 28 different projects. And I want to thank everybody who gave this support. Madam President, Excellencies, ladies and gentlemen, the TFV has redoubled its efforts so as to continue its efforts in the best possible working conditions, so as to offer timely and appropriate indemnities to victims, despite the difficult circumstances affecting the world. they're even more affected and need to be supported by the fund. And that is why it's so important to underscore that over and above the reparations orders that need to be implemented, we also need to do more through the numerous assistance programs that lend assistance to thousands of victims of the events and cases before the court. For several years, there has been this ongoing battle to ensure reparations for victims, so that the perpetrators of the while the perpetrators are being tried before the court. It is important that the victims are not only never forgotten, but duly compensated. Excellencies, ladies and gentlemen, the TFV has been able to overcome several challenges over the last year. It was a rich year in terms of activity, and all of the work that we are currently doing concerning the 4 cases, 3 of them were the eastern DRC in the Ituri province, and one in the north of Mali, which unfortunately is still facing violent conflict. And at the end of 2021, the TFV would like to observe the following. Firstly, when it comes to the Lubanga case, I have the pleasure to inform you that the TFV was able to implement the reparations order through its executing partners. And in March of this year, the collective reparations program was set up so as to support child soldiers and their families. And here we have a very complex program which ensured that more than $9 million were able to be earmarked for the next 5 years. And the program is currently being finalized. Secondly, in the Taganda case, the fund identified the beneficiaries of the reparations indemnities that are going to be given out, and this identification is the first step towards ensuring that the reparations take place, particularly in the Ituri province. We're currently finalizing the implementation of the reparations plan for the Intaganda program, which is closely linked to the Lubanga case, reparations case. And we are expecting this to be finalized by the 17th of December. Third one, in the Intaganda case, the activities for 256 beneficiaries of the fund are going to receive housing, schooling, and other kinds of assistance, and this is imminent. It's important to note that this work was possible thanks to all of the input from the TFV staff in Bunia Kalare and the representative of victims who undertook a lot of work with the registry of the court, as well as in the Gada. And fourthly, when it came to representatives of the Amandi case, there were individual indemnities, but that has now been finalized. A lot of progress have been made concerning the individual reparations. The reparations were given to 794 Ituri-based victims and their families, and they were significant amounts of money. These individual reparations amounted to 361 women who were indemnified and 393 men, and currently receiving individual indemnities to date. Through its executing partners, for the Timbuktu and Haiti partners, those who have suffered economic or moral damages are finally being able to gain the recognition. Also, as part of the implementation of these reparations orders, there have been significant media profiles raised, particularly when it comes to the symbolic reparations through in partnership with UNESCO in Mali, and this all took place on the 3rd of March in Bamako. I was also very honored to be able to be accompanied by Fatou Bensouda at the Bamako at that ceremony. It was a very touching moment which enabled us to recognize the victims of crimes and their communities who'd been affected by the crimes that had been before the court. And finally, with the Wenge court case, at this stage, we're in the early stages, of the process, and the TFV, as we stand here on the 6th of December, we're still looking at the future implementation of reparations, but we're currently at the assistance identification stage. Ladies and gentlemen, the implementation of these reparations is a task that requires a lot of energy. It's an ongoing work, and we have been working with unwavering commitment to ensure that this can occur. And we work very closely with the registry to make sure that the personnel based here in The Hague, with their expertise and all of the people in the registry, we work hand in hand to make sure that this can go ahead. I would like to express my gratitude to the registry, and in particular for all the field staff who have done so much to make sure that this could happen. I am delighted to be able to remind you, to confirm to you that the Trust Fund is still working and to ensure that this good work can continue despite the different. We've got 10 upcoming projects in the Kivus and in the Ituri in the DRC. More than one in the CAR. We have a pilot project in Bangui, which has been a major success, with some 200 beneficiaries from sexual crimes, and in particular, they are still benefiting from our assistance. The TFV has also been able to offer active assistance to victims in Rwanda and in Côte d'Ivoire, in Georgia, Kenya, Mali, and with the other identified areas, the TFV will continue to ensure that this work is ongoing in 2022. Ladies and gentlemen, the implementation of the assistance program is a key part of the TFV's mandate and enables all of those, all the damages suffered by victims to be recognized. We are ensuring we want to make sure that no victims are left behind in Côte d'Ivoire, CAR, Kenya, or wherever the court is active. Moreover, the TFV is actively seeking international cooperation programs across all different countries and works with the civil society and victims' associations when it comes to the implementation of its projects. Madam President, ladies and gentlemen, throughout all of its mandate for the last 3 years, the outgoing board members have given their utmost to ensure that there is a good governance and exercise of the fund's mandate, and we hope that the significant input and contribution made by the TFV over the last few years will be recognized, because and this was only possible thanks to the support that we had received from the registry and the court. But in particular, I should especially like to thank the registrar, who has given us support, advice, and has taken part in many of our meetings when it came to our decision-making process. We've also greatly appreciated the development of the fund with Madam President of the ASP and the President of the Court, the OTP. We have had excellent relations with you throughout our mandate, and within the board, we have in terms of our organization, undertaken the most stringent governance measures to ensure the smooth running of our work. Excellencies, ladies and gentlemen, when it comes to prospects for the future, we're very aware of the concerns of the importance of how the smooth running of the TFV as an independent body must go forward. And we understand the different points of view that have been raised, and we're working very, very hard, hand in hand with states parties, with the registry and the court, to make sure that we can rise to those challenges. Equity and the operational, legal and financial wherewithal for the TFE is necessary if we're going to continue fulfilling our mandate of implementing and recognizing victims under the Rome Statute. But we're not going to be able to do this alone. We need your support, and we need cooperation from states parties if we are to discharge our mandate and lend this important support to victims. Recognizing our unique role in implementing the reparations orders has therefore been something that we can only do with your support. Also, for the friends of the court, remember that there should be no border between our actions and our commitment. It's only through the different institutions and by applying the spirit of the Rome Statute that we can bring this assistance and restore the dignity of victims. So I wanted to express our gratitude for all of your support from many of you. Thank you to you, one and all, for having entrusted us with this task. I wish you the best going forward. And from the very outset, I wanted to extend my thanks to Mali, to my country, which has supported me, and to the African Union for having elected me to represent the African nations for the last 6 years. I should also like to thank and pay tribute to the registrar, to all of the staff at the court for their support and assistance. I remain at your disposal when it comes to supporting victims of international injustices. Thank you very, very much. Thank you very, very much, Mama Koité Doumbia, for her report. And I should like you to please convey to your distinguished colleagues all of the recognition from the Assembly for all of the work that you've been doing for the victims. I just wanted to take this occasion to pay special tribute to you, Madame Koité Doumbia, and Baron Armigna Helic, who are leaving the Board of Directors. The Assembly thanks you for the authority with which you've worked, for your continued efforts, and for your personal commitment in discharging the mandate of the TFV, which is a key aspect of the Rome Statute system. I'm convinced that you will continue to offer your energy and your commitment with the aim of protecting those who were directly affected by violence and crime. So on behalf of the Assembly, I should like to wish you every success in your upcoming activities. I should therefore like to propose that the Assembly take due note of the report of the Board of Directors of the TFV as contained in document 20/14. I see no objection. It is thus decided. That means that we have now concluded our examination of item 11 of the agenda.
Meeting for a few minutes to allow the distinguished head of organs and the chair of the board to leave the podium at this stage. We thank you very much for your presentations today. Distinguished Distinguished representatives, I kindly ask you to return to your seats, so we will continue. We continue to address our agenda. Nous passons maintenant.
Now it is time for us to move on to item 6 of the agenda. In application of Rule 25 of the Rules of Procedure, a credentials committee made up of representatives of 9 states parties is to be appointed by the Assembly at the outset of each session upon the proposal of the President. So following consultations with Member States and recommendation of the Bureau, I'd like to propose Cyprus, Greece, Hungary, Mexico, Romania, El Salvador, Switzerland, and Senegal as members of the Credentials Committee. May I take it that the Assembly accepts my proposal?
Il est ainsi décidé.
It is so decided. So the Assembly will appoint the 2 remaining members of the committee later. I just wanted to remind delegates that in application of Rule 24 of the Rules of Procedure, the credentials stem from the head of state or government or from the Minister of Foreign Affairs or any person duly accredited by one of them. And now it's time to move on to item 7 of our agenda, Organization of Work. The program or schedule of work as proposed by the Bureau as a basis for our work is reflected in the journal dated 6th of December, and I'm sure that you'll all understand that the program is subject to modification depending on how we progress through our various items on the agenda. I should like to ask all representatives to arrive on time for the meeting so that the Assembly will be able to move through all of the different issues and items of the agenda for this 20th session. May I take it then that the Assembly is adopting the program of work as reflected in the journal of the Assembly dated 6th December 2021?
Je ne vois pas d'objection.
I see no objection. It is so decided. Now, the Bureau has suggested that the Assembly meet in plenary and hold informal consultations on some of the key issues for decision-making. After its meeting on the 24th of November of this year, the Bureau recommended that the following people be appointed coordinators of the Assembly for this session. First of all, for the working group on the budget, it'll be Ambassador Frances Galatia Lanitu Williams from Cyprus. And for informal consultations on the omnibus resolution, Mr. Vincent Rittener. May I take it then that the Assembly would like to move in this direction? I see no objection. It is so decided. My congratulations to Ambassador Frances Galatea Williams of Cyprus and Mr. Vincent Rittener from Switzerland, and I wish you every success as you discharge your tasks. And I know that you can count on the support of the Bureau.
And now, distinguished representatives, we will now turn to agenda item 5, States in Arrears. While most state parties paid their contributions in a timely manner, the amount of outstanding contributions increased this year. This generated an extremely serious liquidity crisis in the last trimester that threatened the capacity of the court to fulfill its financial obligations. I note that taking stock of the crisis experienced in recent years, the Bureau started to consider the situation early on this year, continued to monitor the situation on an ongoing basis throughout the year, and later took appropriate actions to avert the crisis. I would like to thank the two vice presidents, the facilitators on arrears, and the registrar, and the facilitator on the budget for their tireless efforts to obtain payment of outstanding contributions. I also engaged personally with representatives of relevant states to this effect. I am happy to report that this collective endeavor resulted in some key payments being made, which combined with advance payments for 2022 by other states, averted the liquidity crisis from materializing. I thank the governments of state parties that made payments, either to remove or reduce arrears. I also wish to express my deep appreciation to those states that contributed to solve the situation by making advance payments for 2022, while underscoring that such advance payments should not by any means become a common practice of this Assembly. The lack of timely payment of contributions has become a recurring problem and thus a matter of serious concern. We need to keep this issue under review and continue to consider the relevant recommendations of the report of the Independent Expert Review, the Committee on Budget and Finance, and the external auditors and other bodies. As regards voting rights, according to Article 112, paragraph 8 of the Rome Statute, a state party which is in the arrears in the payment of its financial contributions towards the cost of the court shall have no vote in the Assembly and in the Bureau if the amount of its arrears equals or exceeds the amount of the contributions due from the preceding 2 full years. The Assembly may nevertheless permit such a state party to vote in the Assembly and in the Bureau if it is satisfied that the failure to pay is due to conditions beyond the control of the state party. The Secretariat sent a note verbal dated 15 November 2021 to all concerned states via their United Nations missions, as well as their embassies in The Hague and Brussels, informing them that they were in arrears, recalling the provisions of Resolution ICC ASP/4 Resolution 4 on the request for exemptions, as well as stating the minimum payment required to avoid the application of Article 112, paragraph 8 of the Rome Statute. In accordance with information provided by the Court, it would appear that Article 112, paragraph 8 of the Rome Statute is currently applicable to 9 states parties: Antigua and Barbuda, Central African Republic, Comoros, Congo, Guinea, Liberia, Suriname, Bolivarian Republic of Venezuela, and Zambia. The Bureau considered the question of requests for an the questions of potential requests for an exception from the loss of voting rights, taking into account a number of elements. The practice so far to grant all requests for waiver formally submitted by state parties, to which Article 112, paragraph 8 applies, the relevant recommendations of the Committee on Budget and Finance, including as its most recent September session, the particularly serious liquidity crisis, which posed a serious risk of affecting some of the court's operations, as well as the exceptional and unprecedented circumstances generated by the COVID-19 pandemic. In light of the above, the Bureau decided to recommend to the Assembly to grant the waivers, if requested, due to the exceptional COVID-19 circumstances faced by state parties in 2021. However, it was also agreed that the current practice in relation to such waivers could change in 2022 should such circumstances improve. I would like to underline the importance of endowing the court with the necessary financial resources. I encourage all state parties to transfer their assessed contributions in full and on time, or in the event of pre-existing arrears, immediately, in accordance with Article 115 of the Statute and Rules 105.1 of the Financial Regulations and Rules. I would also like to invite other state parties that are subject to Article 112.8 of the Rome Statute that wish to request an exemption from the loss of voting rights to submit a formal request via the Secretariat of the Assembly of State Parties. Now we turn to item 11 of the agenda, which is review of the International Criminal Court and the Rome Statute system. The Assembly has before it the report of the review mechanism submitted pursuant to ICC ASP/19/Resolution 7, which is contained in document ICC ASP20/36. I will now give the floor to the two state parties' representatives who have led the work of the review mechanism in The Hague and in New York, Ambassador Paul van den Ijssel from the Netherlands and Ambassador Michael Kanu of Sierra Leone. I invite them to come to introduce their reports from the lectern.
Gracias, President. It will be a two-man show. Michael will join me, and he will do the second part of the report. And we try to be relatively short because we will have a substantive meeting on the review this Wednesday. So I thank you very much, Madam President, for giving us the possibility to introduce the report of the review mechanism, which we submitted pursuant to ICC ASP19 Resolution 7 of last year, paragraph 9. In that resolution, the Assembly has requested the mechanism to submit a report on the review process well in advance of the 20th session. And I do apologize a little bit because the well in advance became only a couple of days. I hope for some understanding. In the report, we should say something on the progress in the assessment of and possible further action on the recommendations of the independent experts review and the measures for implementation of the review process. We should say something about progress in the work of the relevant Assembly mandates on the issues referenced in ICC ASP18 Res 7, paragraphs 18 and 19, and any other progress in the review process. The report indicates that the review mechanism carried out the tasks requested of it and lists the reports which the mechanism submitted, namely the categorization of the independent expert recommendations and remaining review issues, which is submitted to the Bureau on 30th of April and which the Bureau adopted on the 31st of May 2021. On the 30th of June, the review mechanism submitted a proposal for a comprehensive action plan for the assessment of the recommendations of the independent experts, which the Bureau adopted on the 28th of July 2021. And by adopting the comprehensive action plan as proposed by the review mechanism, the Bureau accepted the working method proposed by the review mechanism, in which states parties will be involved in the discussions on the assessment and implementation of recommendations, giving effect to the need for continuing inclusivity and transparency, in accordance with Resolution 19-7 of last year, by designating platforms for discussion of all recommendations. Also on the 30th of June, the mechanism submitted a report on the overall progress of work. The Comprehensive Action Plan sets out the timeline for assessment of the IR recommendations. The second half of 2021, dates in 2022, and a few remaining ones in 2023. It also indicates the entities that are responsible for the assessment. The work of the mechanism on this comprehensive document was complex and benefited greatly from the inputs of states parties, ASP mandate holders, the ASP presidency, the court focal points, and individual officers of the court, the Staff Union Council, civil society, and ICCBA. As part of its working method, the mechanism routinely consulted these entities at each stage of its work. We note in the report that, like the categorization, the review mechanism considers the Comprehensive Action Plan as the roadmap for the assessment of all the recommendations throughout the review process. The mechanism noted that some recommendations were assessed earlier than the timelines in the Comprehensive Action Plan, and we welcome, of course, this progress. At the same time, we also note that the assessment of some recommendations expected to be completed in 2021 is still ongoing and will be completed in 2022. We welcome the work of the facilitators on the IR recommendations and are grateful that they considered the recommendations that had been assigned to them in the Comprehensive Action Plan as the platform of discussion. The mechanism also submitted a further report on its role as the platform for the discussions of recommendations which is assigned to itself. That means those recommendations for which the review mechanism itself serves as an ASP mandate holder in accordance with the resolution. Finally, the review mechanism submitted the report of the review mechanism. The report I'm now introducing, this report also contains two annexes. Annex 1 is the list of reports of the Assembly mandate holders that report on their work on the respective IER recommendations. Annex 2 contains a matrix titled Progress in the Assessment of the IR recommendations. I stop here and ask my dear colleague and friend Michael Carney to take over. Michael, please.
Thank you, Ambassador van der Ijssel. Madam President, Excellencies. As indicated in our message by which we circulated the matrix on Friday, the matrix is a purely factual overview of the states of the review as an informative tool to state parties and other stakeholders. It should be read in conjunction with the Comprehensive Action Plan. It covers those recommendations that were due to be assessed in 2021 according to the Comprehensive Action Plan. Where some recommendations indicated in the Comprehensive Action Plan for assessment in 2022 were already assessed this year, the outcome of those assessments has also been reflected. We noted in our report that the matrix contains information from the report of the different facilitations, and once more we thank and commend the ASP mandate holders for their work in having all the recommendations assigned to them assessed. We also indicated that the information on implementation deadlines is also taken from the reports and was also cross-checked with the court. Also, I would like to once more stress that these timelines were meant to be indicative and can be further discussed in the appropriate facilitations. We would like to highlight that the matrix is a living document, and we intend to update it regularly in order to provide a regular overview of the state of review. This also means we address mistakes in the matrix on an ongoing basis as we consult with the Assembly mandate holders and the court focal point. The review takes full responsibility for all or any of the mistakes you will find in the matrix. As we are aware, the review mechanism is currently holding negotiations on a draft standalone resolution on the review of the court and the Rome Statute system. We have made significant progress, and there are a couple of outstanding issues which we hope to resolve during the course of today's through an informal discussion, as well as the informal consultation that will take place this evening at 1800 hours after the general debate. And we hope to finalize the text today, and we look forward to your cooperation and constructive engagement. Finally, Madam President, I wish, on behalf of all the members of the review mechanism, to express our deep appreciation to the court focal point, Mr. James Stewart, Deputy Prosecutor, Mr. Hirab Abtai, the Chef de Cabinet of the ICC Presidency, Mr. Osvaldo Zavala Giller, Senior Special Assistant to the Registrar, for their consistent dialogue, their openness and willingness to share ideas and information. They have greatly assisted the review mechanism in its mandate during this year. The state party representatives are grateful to the Ad Country Focal Point, Bangladesh, Chile, and Poland, for their unstinting support and positive spirit, which has greatly facilitated our work. We also express appreciation to other staff of the court, the Staff Union Council, members of civil society, and the International Criminal Court Bar Association, those who have made valuable contribution to our deliberation. We also wish to thank the staff of the Secretariat of the ASP for their dedicated work in assisting the review mechanism in this important work in challenging circumstances and within the ambitious timeline. This concludes our report, Madam President, and I thank you for your kind attention.
Thank you very much. I thank Ambassador van den Eysel and Ambassador Kanu for the introduction of the report. I would also like to thank them both, as well as the other members of the review mechanism, for their tireless efforts in fulfilling their crucial mandate. As already indicated by Ambassador van den Eysel, we shall revert to this agenda item at our plenary meeting on Wednesday afternoon. Now, distinguished delegates, let us now turn to agenda item 4 on election of Bureau members. You will recall that at the first resumption of the 19th session, the Assembly elected the members of the Bureau for the 20th to 22nd sessions and noted that at the Bureau's 17th meeting on 12 January 2021, the Bureau had taken note of the seat-sharing arrangements agreed by the group of Asia-Pacific states and the Western European and other states groups. In order to ensure a seamless transition of Bureau members where there has been an internal seat-sharing arrangement, and to dispense with having an election of some Bureau members at each session of the Assembly, the Bureau recommends that the following members of the Bureau be elected according to the internal agreement as follows. In the Asia-Pacific group, Bangladesh would be elected for 2023. Japan and the Republic of Korea would be elected for 2022-2023. And in the Western European and other state groups, Germany would be elected for 2022-2023 as of 13 February 2022. Does the Assembly agree to proceed in this manner? I see no objection. It is so decided. Thus, Bangladesh is elected Bureau member for 2023, Japan and the Republic of Korea for 2022-2023, and Germany for 2022-2023 as of 13 February 2022. We have thus concluded our consideration of item 4. Now, before we move on to the next agenda item, I wish to indicate that the Bureau decided to recommend that the Assembly appoint Mr. Jules Thierry Legbo, Côte d'Ivoire, as rapporteur for the 20th session. Does the Assembly agree to appoint Mr. Jules Thierry Legbo, Côte d'Ivoire, as rapporteur for the 20th session? I see no objection. It is so decided. Let us now turn, distinguished colleagues, to agenda item 14, election of the members of the Board of Directors of the Trust Fund for Victims. The Assembly will now proceed to elect 5 members of the Board of Directors to fill the vacancies arising upon the expiration of the terms of office of the members of the board elected at the 17th session. The note by the Secretariat contained in document ICC ASP20/18 sets out the procedure for the election of the members of the board pursuant to resolution ICC ASP/1 Resolution 7. At its 4th meeting on 2 June 2021, the Bureau fixed the nomination period to run for 12 weeks, from 7 June to 29 August 2021 Central European Time. At the end of that period, since the number of candidates remained less than the number of seats, and in accordance with Resolution 7, paragraph 4, the nomination period was extended to 12 September. At the close of the nomination period, 5 candidates had been nominated for the 5 available seats. The list of candidates and the supporting documents are contained in the note by the Secretariat entitled 7th Election of Members of the Boards of Directors of the Trust Fund for Victims, ICC ASP/20/18. This list of candidates goes as follows: Mr. Sheikh Mohammed Belal, Bangladesh; Mr. Kevin Kelly, Ireland; Mr. Andres Parmas, Estonia; Ms. Minerva Josefina Tavares Mirabal, Dominican Republic; Mr. Ibrahim Sori Yilal, Sierra Leone. The curricula vitae of the above-mentioned candidates and supporting documentation are contained in the annex to the note by the Secretariat. Paragraph 3 of the annex to Resolution ICC ASP/1/Resolution 6 on the establishment of the Trust Fund provides, and I quote, "The Assembly shall elect the members of the board, all of whom shall be of a different nationality on the basis of equitable geographical distribution and taking into account the need to ensure equitable gender distribution and equitable representation of the principal legal systems of the world. The members of the board shall be of high moral character, impartiality, and integrity, and shall have competence in the assistance of victims of serious crimes." Resolution ICC ASP/1/Resolution 7 on the procedure for the nomination and election of the members of the board provides in paragraph 8 for the regional distribution of seats as follows: African states, 1 seat; Asian states, 1 seat; Eastern European states, 1 seat; Group of Latin American and Caribbean states, 1 seat; and Western European and other states, 1 seat. Paragraph 9 of Resolution ICC ASP/1/Resolution 7 provides that the election of members of the Board of Directors shall be a matter of substance and subject to the provisions of Article 112, Paragraph 7A of the Rome Statute. Paragraph 10 of the same resolution provides that every effort shall be made to elect the members of the board by consensus. The requirement for a secret ballot shall be dispensed with if the number of candidates corresponds to the numbers of seats to be filled, or in respect of candidates endorsed by the respective regional group, unless a delegation specifically requests a vote. Distinguished delegates, since the number of candidates corresponds to the number of seats to be filled, I would propose, on the basis of the 3rd November 2021 recommendation of the Bureau, that the Assembly dispense with a secret ballot in accordance with paragraph 10 of Resolution ICC ASP1 Resolution 7 and elect the candidates by acclamation. Is this agreeable to the Assembly? I see no objection. It is so decided. The Assembly therefore elects by acclamation the following 5 members of the Board of Directors of the Trust Fund for Victims: Mr. Sheikh Mohammed Belal, Bangladesh; Mr. Kevin Kelly, Ireland; Mr. Andrés Parmasa, Estonia; Ms. Minerva Josefina Tavares Mirabal, Dominican Republic; Mr. Ibrahim Sori Gilach, Sierra Leone. The 3-year terms of office of the members of the board elected at this meeting will commence on tomorrow, 7 December 2021. On behalf of the Assembly, I congratulate the members of the Board of Directors of the Trust Fund for Victims and wish them every success in their discharge of their important responsibilities towards the victims of the crimes within the jurisdiction of the court and their families. The Assembly has thus concluded its consideration on Agenda Item 14. We shall now take up Agenda Item 15, election of the members of the Advisory Committee on Nomination of Judges. I wish to recall that Article 36, Paragraph 4C of the Rome Statute provides as follows. The Assembly of State Parties may decide to establish, if appropriate, an advisory committee on nominations. In that event, the committee's composition and mandate shall be established by the Assembly of State Parties. The terms of reference of the Advisory Committee on Nominations set out in document ICC ASP/10/13, which is the report of the Bureau on the establishment of an Advisory Committee on Nominations of Judges of the ICC, provide inter alia that the committee should be composed of 9 members, nationals of state parties, designated by the Assembly of State Parties by consensus on recommendation made by the Bureau of the Assembly, also made by consensus, reflecting the principal legal systems of the world and an equitable geographical representation, as well as a fair representation of both genders based on the number of state parties to the Rome Statute. At its 3rd meeting on 12 May 2021, the Bureau fixed the nomination period to run for 12 weeks from 7 June to 29 August 2021 Central European Time. Nominating states were requested to include a statement as to how candidates fulfill the criteria established in the terms of reference of the Advisory Committee. At the end of that period, Since the number of candidates remained less than the number of seats, the nomination period was extended to 12 September. At the close of the nomination period, 9 candidates had been nominated for the 9 available seats. The list of candidates and the supporting documents are contained in the note by the Secretariat entitled Election of Members of the Advisory Committee on Nomination of Judges, ICC ASP20/19. On 24th November 2021, the Bureau agreed to recommend that the Assembly elect by acclamation the following 9 candidates to the Advisory Committee on the Nomination of Judges. Mr. Denis Dominique Adjei, Ghana, Mr. Julian Fernandez, France, Ms. Lucy Mutoni Kambuni, Kenya, Ms. Milika Kolakovic-Bojovic, Serbia, Mr. Erkki Kurula, Finland, Ms. Sanji Masenono Monaghan, Botswana, Mr. Mauro Politi, Italy, Mr. Eduardo Rodriguez Belce, Bolivia, and Mr. Sang-Hyu Song, Republic of Korea. The terms of reference of the Advisory Committee, as I just explained, require that the members be designated by the Assembly by consensus. I understand that some additional time is required for consultations, so we will thus need to defer the election and revert to this item at one of our next plenary sessions. Distinguished delegates, we have concluded our business for the first plenary meeting. We will meet here at 3 p.m., 15 hours sharp, to begin the general debate. I wish to announce that the Credentials Committee will meet immediately following the adjournment of this meeting in the Antarctica Conference Room. Members of the Credential Committee may use the door to the left, to go to the conference room. I wish you all a pleasant lunch break and see you back here at 3 o'clock.